Okay, so I think we're ready to go. Welcome, everyone, and thank you for joining us. Just before we get started, I want to give folks a heads up that we are recording this webinar in case you didn't get a notification. So, my name is Evan Brunner. I am a program and policy consultant here at the Commission in our Communication, Education, and Engagement branch. Today's webinar is intended to do several things. So, what we're hoping is to provide up to date human rights principles based on decisions made by human rights panels, tribunals, and courts to support knowledge mobilization and policy development. We're hoping to inform employers of their rights and responsibilities related to preventing discrimination and the duty to accommodate to undue hardship, inform individuals of their rights and responsibilities in the area of employment, specifically as it relates to the Act's protections of gender and family status, provide practical applications of the resources, human rights principles to facilitate organizational capacity building, and to spotlight the most updated version of our Human Rights Pregnancy and Parental Rights and Responsibilities Human Rights Guide, which I'll talk about more in a couple of slides. But before we really dive into the nitty-gritty of everything, we would like to state a land acknowledgement. So the Alberta Human Rights Commission acknowledges that what we call Alberta is the traditional and ancestral territories and gathering places for diverse Indigenous peoples. This includes 45 First Nations and 140 reserves who are subject to Treaties 6, 7, and 8, as well as Métis settlements and lands, the six regions of Otipemisiwak, Métis Nation of Alberta, sorry, Otipemisiwak, apologies, as well as Inuit peoples who have lived in and cared for these lands for generations. We are grateful for the traditional knowledge keepers and elders who are still with us today and those who have gone before us. We respect and honor the treaties that were made on all territories, and we recognize the harms and injustices of the past and are committed to moving forward in partnership with Indigenous peoples in the spirit of reconciliation and collaboration to remove barriers and address discrimination. Additionally, with this land acknowledgement, we also like to recognize that the land and Indigenous peoples, both past and present, are intrinsically tied together. We acknowledge not only the land that was taken, but also those who were taken from it. We respect, honor, and are committed to supporting the journey of those still struggling to come home to their lands, their ancestors, and their culture. So, just some quick housekeeping. First of all, again, like I mentioned, the webinar is being recorded, but this includes if you experience any technical difficulties or potentially need to leave, you can come back later and look at the recording, which will be on our website. The captioning link will also be available. As folks should be able to see, we do have ASL interpreters for our friends who require them. The current presenter and both of our ASL interpreters will be spotlit on your screen throughout the webinar. For those who require closed captioning, please click on the chat box, which will open up in a new browser. Splitting your screen will allow you to view the webinar and the ongoing transcript simultaneously. And finally, please submit any questions you may have to our Q&A box throughout the presentation, and we will get to them at the end of the webinar. Please note that because we have so many folks joining us today, submit your questions through the Q&A box, and then we can triage them as we come in and hopefully get to as many as possible. So, as mentioned earlier, one of the goals of this webinar is to spotlight the most updated version of our Human Rights Pregnancy and Parental Rights and Responsibilities Human Rights Guide. That is a long term, but this is a really important document. So, this updated 2022 version explains the provisions of the Alberta Human Rights Act as they apply to pregnancy, chest feeding, maternity, and parental leave, adoption, and childcare obligations. It provides resources for finding more information and includes current and relevant Alberta case law. You will have received a link to this guide in your registration email, and we will also be providing the link again in the chat box as well as via email following today's session. And of course, it will be available on our website in case you don't have access to it. So, I'm sure folks are already tired of hearing my voice, so we shall jump into our speakers. So, our speakers today are Catherine Oviatt, Chief of the Commission and Tribunals with the Alberta Human Rights Commission, and Rena Kular, Human Resources Executive and Chartered Professional in Human Resources with Agilis Executive Consulting. Before I turn things over to Catherine, let me tell you a bit about her. So, prior to her appointment as chief of the commission and tribunals, Catherine Oviatt was appointed to many boards and tribunals, including 3 terms as a member of the commission, where she was a leader on the tribunal. She has spent her entire legal career practicing in administrative law, and since 2015 has exclusively practiced as a neutral adjudicator, including in human rights as a labor arbitrator. Ms. Oviatt has published more than 140 public decisions, many which are leading cases in Alberta human rights law. Most recently, she was appointed as King's Counsel. So, on that note, I will hand it over to you, Catherine, to kick things off. Welcome. Thank you for coming today. And I will stop sharing my screen so that you can share your slides.
Thank you so much, Evan, and thank you everyone for your patience. Just let me get my slides up on the screen so that you have a visual of what I'm talking about. All right, I hope that you can see that. It is a pleasure to be here speaking to you about pregnancy, parenting, and human rights. As Evan outlined, our presentation is divided into 2 sections. I'm going to speak about the law. I have a very short time frame, so my intent is to give you a high-level summary that frames the legal context, and then Rena will step in for a practical human resources approach. And hopefully, the combination of our presentations will bring you both a deeper understanding of the legal principles and also some tools for moving forward in your workplaces. So I'm still new to webinars, so I hope that my slides are working for you, and I'll ask Evan and others to jump in if we need any guidance. The first thing is, when we speak of legal rights and responsibilities, we always have to start with the legislation. The Alberta Human Rights Act is the anti-discrimination legislation in Alberta. Many of you will be familiar with the Charter of Rights and Freedoms included in the Constitution. And of course, the Charter is the highest law of our land and reflects our highest moral and legal obligations. But it also really only applies to government actions and inactions. So that's why we need the Alberta Human Rights Act. It speaks more to our day-to-day public interactions. The Alberta Human Rights Act has lofty and noble goals, including that it recognizes the equality and the inherent dignity of every person, regardless of race, religious beliefs, color, gender identity, gender expression, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, family status, or sexual orientation. These are the grounds or the characteristics that are protected in the Act. And they are protected in a number of areas. The Act does not prohibit all discrimination. It's only discrimination that comes in one of those identified areas on one of those identified grounds. And the areas include publications and notices, goods and services customarily available to the public, tenancy, employment, and membership in trade unions, amongst others. And these areas tend to protect our participation in public life, not our private interactions within our families or private relationships. Rather, they speak to our ability to access goods and services, to get an apartment, or to get a job. Today's presentation is focused on gender discrimination in employment. And this is really critical because in our last annual report, the Commission identified that 78% of all human rights complaints were made in the area of employment. How we make our living and how we work through the world is so critical to our well-being and our dignity. We also know that pregnant workers are incredibly vulnerable. It can be hard to get a job while pregnant, or a person may be chosen for layoff because of their pregnancy. And those are exactly the sorts of problems that the Act is designed to correct and protect against. So, looking more specifically at pregnancy discrimination, and particularly in employment. The Act addresses employment discrimination in Section 7, and that provides in part, no employer shall refuse to employ, refuse to continue to employ, or discriminate in employment because of gender or family status. Section 44 sub 2 helpfully clarifies that gender includes pregnancy. That was long understood by lawyers and adjudicators, but it is helpfully clear now in the legislation. So if there was ever any doubt, pregnancy is gender. Discrimination can come in many forms, and particularly within employment, it might be demotion, harassment, or termination. And that includes for miscarriages, breastfeeding or chest feeding, and all aspects related to pregnancy. Evan highlighted for you the new pregnancy guide of the Commission, and I would refer you to that for more details and examples. But some of the examples that the guide outlines come from case law and decisions that tribunals and courts have made. And some of those examples are like creating hostile working conditions due to pregnancy, preventing breastfeeding or chest feeding in public or at work, or refusing to accommodate them, asking individuals on job applications or in job interviews if they are pregnant or plan to have children, refusing to hire a potential employee because of pregnancy or breastfeeding or fear that they might become pregnant or breastfeed or chest feed, refusing to consider an employee for promotion because of pregnancy, firing, layoff, demoting, or reassigning an employee because they are pregnant or breastfeeding, failing to accommodate to the point of undue hardship medical restrictions that are in place during pregnancy, or denying the employee the choice between a maternity leave or a valid medical leave. And those are just examples. So I turn now to a legal term of art, and that is, what do we mean when we say the word discrimination? In short, it is where a protected characteristic like gender is a factor in something bad happening to a person. There is a legal test for discrimination, and it has 3 steps. Lawyers love 3-part tests, and the test for discrimination is no different. So step 1, does the person have a protected characteristic? For a pregnant employee, as we've discussed, that is their gender. Step 2, did the person experience negative treatment or a negative impact? Again, something like harassment, demotion, termination. And then step 3, was the person's protected characteristic, here their gender, a factor in that negative treatment? The law is incredibly clear that gender of pregnancy does not have to be the only or even the main factor. As long as it is a factor at all, that is discrimination. So, for example, if an employer wanted to replace an employee because they were the wrong fit, they can do that as long as pregnancy is not a factor in that. So if it's 90% fit and 10% pregnancy, because of that 10%, it is still discrimination. As long as the pregnancy is a factor, you will get to discrimination. And so to illustrate the point, I've given a short example. And I know you can read the example, but I'll just highlight some of the points. So Sarah, she's a relatively new employee, less than 6 months in the job. She's doing an adequate job, but she's not a top performer. I'm going to call her a medium employee. The employer neither loves her nor hates her. She gets pregnant and she's planning a mat leave. The employer decides they're going to terminate Sarah's employment and they hire a replacement who they hope they're going to like better. They're going to be a better performer. So if I'm looking at this to say, is this discrimination? I'm going to go back to that 3-part test. So number 1, Does Sarah have a protected characteristic? Yes, Sarah is pregnant. That's gender. Step 2, did Sarah experience negative treatment? Yes, she lost her job. And step 3, was Sarah's pregnancy a factor in her termination? And as an adjudicator, I will tell you that this is the most common area where the test gets interesting and is often the stickiest point. But I would say on these facts, and I appreciate they're bare facts without a lot of details, it looks like yes. So the fact scenario says she's doing a fine job, not amazing, but adequate. Presumably, before she announced her pregnancy, there was no plan to replace her. Then she announces her pregnancy and she's fired. The timing alone seems like Sarah's pregnancy raised that it was a convenient time for her employer to replace her. So that makes her pregnancy a factor in the termination. So for me looking at this, and again, limited facts, it looks like this was discrimination. And what I really want to highlight is what will and will not constitute discrimination depends a lot on the circumstances, and it most often turns on that last bit. Was the pregnancy a factor in the negative treatment? And again, it only needs to be a factor, not the main, not the sole, or not the overriding. As long as it's a factor, that's discrimination. So I want to turn to a different concept now, and that is the duty to accommodate. Now, that 3-part test that we just discussed can be answered with a defense. And that defense is if the employer reasonably accommodated to the point of undue hardship. Now, I'm using the words undue hardship deliberately because those are the words that come from the Supreme Court of Canada, and the court is very careful. And the court has actually considered whether it should get rid of the word undue and has decided no, we're keeping that word undue in there. And that's really important because it signals that the court is saying to employers, you have to assume some hardship. It's only undue hardship where you will answer the test. And so one of the cases says this could be serious business disruption, onerous financial cost, or health and safety risks. And again, they're using modifiers: serious, onerous. So some business disruption, some financial costs, those are things employers are expected to absorb. It's only the serious and the onerous. The duty to accommodate is all about getting people who can work to work. And so if that means part-time, revised schedules, flexible work arrangements, modified duties, that's what you're required to do. Get the person who can work to work. And be creative and engage a process that fully explores options. Now, the legal principles apply equally to employers and employees, but I have a slightly different message for each based on those same equal principles. To employers, I want to emphasize how high the threshold of undue hardship is, and how you as an organization need to do everything reasonable in your power to keep the person at work. To employees, I want to remind you that it is reasonable accommodation, and you will have to accept reasonable options, even if they are not your preferred or perfect accommodation solutions. The process is flexible and problem solving, and that requires both employees and employers to be reasonable, candid, and transparent, and open to problem solving. So again, I've got another example for you, and this is a duty to accommodate example. So this is a pregnant employee with a medical restriction about lifting. So in this example, Anna is 5 months pregnant and intends to take parental leave after the birth of her child. So she's got about 3 to 4 months left before she's going to go on maternity leave. But she develops medical complications in her pregnancy, and her doctor writes her a medical note indicating that she cannot lift more than 10 pounds during her pregnancy. Her job duties include both desk duties and stocking shelves with weights between 5 and 20 pounds. Anna's employer demands that she take her maternity leave early. Now, what we know from this fact scenario, and again, it's just something I made up and we don't have all the details, but we know that because some of her job duties include stocking shelves up to 20 pounds and she can only lift at 10 pounds or below, she can't do all of her job duties. So we know that. But was it reasonable for the employer to just say, take your mat leave early? Now, based on what we know, I'm going to say no. The employer needs to look at her job duties and see what she can do. Every workplace is a little different, so each solution is going to be a little bit different. The employer is in the best position to find a solution. But here it looks like Anna could still do most of her job duties. She can do the desk duties and she can do some lifting to a maximum. Now, we don't have the details of how much of the lifting is and how much of her job duties that is. And so that's the exact sort of discussion that the employer and Anna need to explore together to look for options to find a way to keep her at work safely. Turning now to access to medical leave and benefits. The guide is a little more detailed than I intend to be. And so again, I'll refer you to that as a reference material. But what I want to highlight here is that pregnancy may include a valid health-related reason for absence from the workplace. A pregnant employee may need to have both medical leave and a parental leave as separate, distinct leaves. And further, an employer is required to provide benefits packages in a non-discriminatory manner. A pregnant employee should not have to choose between a voluntary leave and a health-related leave if they have both a medical condition and a need for parental leave. Benefit plans will differ from one employer to another, of course, but employers have to make sure that their benefit plans do not discriminate against employees taking a valid health-related leave during or following pregnancy. Now, my last topic for discussion is about family status. So what happens after the baby is born, the adoption completed, and the parental leave ends? Most of us have the ability to figure out our schedules, but some caregiving obligations cannot be adapted. And that may be particularly so for unique family arrangements or families that involve disabilities. As parents, we have a legal obligation to provide and care for our children. And we may also have a need to work in order to meet that obligation. Family status is a protected characteristic in the Alberta Human Rights Act, meaning both that an employer cannot discriminate based on family status and that there is a duty to accommodate family status. Most often, family status discrimination will relate to a worker's caregiving obligations. I will tell you candidly and openly, this is still a developing area of the law. It's somewhat complex. But what I want to emphasize is that the exact same principles that I've already discussed about pregnancy discrimination apply to family status discrimination. An employer cannot refuse to employ, refuse to continue to employ, or discriminate in employment due to a person's family status, including whether they have children, have childcare obligations, or need to breastfeed or chest feed. And that's not an exclusive list, that's just some examples. Correspondingly, employers have a duty to accommodate to the point of undue hardship. That accommodation process is one of collaboration, discussion, and problem solving between both the employer and the employee. And neither side can dictate how that will go, and both have to be reasonable. In the interest of time, I just want to give you some examples of things that might be possible. Again, the idea is that we are creative and looking for solutions for how we can keep the person who can work at work. Some examples can include providing flexible work hours, granting leave for family caregiving, or allowing alternative work arrangements like hybrid or work from home. Again, each workplace is different, and so each accommodation will have to be different. And I encourage you to approach accommodation discussions openly and flexibly. So just some concluding thoughts before I pass the torch over to our more practical human resources specialist. Being pregnant in the workplace can be an incredibly vulnerable experience, and I would encourage employers to remember that. There can be a tendency for some employers to view accommodation of pregnant employees as an inconvenience. However, the responsibilities under the Act provide a workplace free from discrimination, including the responsibility to accommodate to the point of undue hardship, are legal obligations. They are not simply morally the right thing to do. They are the law. Ultimately, I think the law is correct because it allows everyone to participate fully in the workforce. When we protect pregnant workers, we are building a better community, including a better business community where everyone can thrive and contribute. And so those are my remarks. Thank you. And I'll turn the time back to Evan to introduce our next speaker and talk about practical tools and approaches.
Awesome. Thank you so much, Catherine. And I'm going to go and share my screen again. There we go. Okay, so thanks again, Catherine, for going through that. So now we're going to jump over to our next presenter, Rena Kular. So a bio on Rena. Rena is a human resources executive with a background in HR strategy and consultation. She is specialized in developing and implementing HR programs for organizations globally, providing a competitive advantage for its people, business, and strategic success. Ms. Kular holds a Bachelor of Commerce with a major in Human Resources Management, a designated CPHR Chartered Professional in Human Resources in Canada, and a Society for Human Resource Management Senior Certified Professional designation in the United States. With over 22 years of experience in the professional services industry, she has extensive knowledge of interpreting, developing, and executing processes to support organizational guidelines and regulations to legal matters related to the employee experience and people strategies. So welcome, Rena. Thank you so much for coming. And yeah, we look forward to your presentation.
Well, thank you. Thank you so much, Evan, and thank you, Catherine, as well. My information here will definitely supplement some of the great legalities that Catherine went through for this webinar. Today, what we'll focus on from a human resources perspective is as an HR leader in an organization, it's important to take note that your employment standards code is the perfect guide for you to develop policies and regulations and guidelines for your organization. And that goes for any leader in an organization. If you're a human resources leader or any department, definitely have an opportunity to connect with that guide, including the guide that we are speaking about today. So my presentation is going to be going through creating policies and practices around working and expecting. We'll talk a little bit about ensuring maternity and parental accommodation and benefit processes are clear when creating those guidelines. And guidelines for returning to work. Again, as Catherine had mentioned, the pregnancy and the process and employees, it is such a sensitive time. And so ensuring that you have your processes outlined clearly in the form of a guide is going to benefit your organization and you as a leader as well. So we'll talk a little bit about creating those guidelines and return to work. We'll talk about outlining availability of accommodation for breastfeeding and chest feeding. And we'll also discuss returning to work and guidance on how to terminate your EI benefits. So where Service Canada comes in as well as your support. So working and expecting. Employees are eligible for maternity and parental leave if they have been employed at least 90 days with the same employer. Employees with less than 90 days of employment may still be granted leave. However, their employers aren't required under employment standards legislation to grant them leave. Eligible employees can take time off work without pay for maternity and parental leave without the risk of losing their jobs. Employers must grant maternity and parental leave to eligible employees and give them their same or equivalent rolls back when they return to work. Employers aren't required to pay wages or benefits during leave unless stated in the employment contract or a collective agreement. Employees on maternity or parental leave are considered to be continuously employed for the purposes of calculating years of service. The length of maternity leave is 16 weeks, and the maximum length of parental week is 62 weeks. Employers can't discriminate against, lay off, or terminate an employee or require them to resign because of pregnancy or childbirth. If both parents work for the same employer, the employer isn't required to grant parental leave to both employees at the same time. When giving notice, if you are pregnant and taking leave, or if your employees are going to be giving notice, you are, as an employer, require employees to submit a medical certificate confirming pregnancy and estimated delivery date. A medical certificate may be issued by a nurse practitioner or physician. When starting leave, employees must give employers written notice of at least 6 weeks before starting maternity or parental leave. Employees aren't required to specify a specific return date at that time, but they may wish to do so. If they fail to give notice for medical reasons or a situation related to birth or adoption, parents are still eligible for the leave. For maternity leave, providing written notice and a medical certificate to the employer within 2 weeks of the mother's last day of work or as soon as possible. For parental leave, providing written notice to the employer as soon as possible. A birth mother on maternity leave isn't required to give her employer notice before taking parental leave unless she originally arranged to take only 16 weeks of maternity leave. Parents who intend to share their parental leave must advise their respective employers of their intention to do so. 2 employees working for the same employer may combine parental leave for a maximum of 62 weeks. Employers do have a duty to accommodate their employees. During the accommodation process, as Catherine had mentioned, both the person seeking accommodation and the employer have the rights and responsibilities to fulfill. You and your employer should discuss how best to accommodate your pregnancy, and employers are also expected to be flexible when accommodating pregnant employees. But as an employee, you are also expected to be able to cooperate when your employer makes an effort to accommodate you as well. When we talk about maternity and parental benefits, individuals who meet certain requirements may receive federal EI benefits, maternity benefits. Employment insurance includes maternity benefits for biological and surrogate parents who are unable to work because they are pregnant or have recently given birth. Parental benefits are also available through the employment insurance program. Parents may apply for these benefits if they are caring for a newborn, a newly adopted child, or other children. Birth mothers can take up to 16 consecutive weeks of unpaid maternity leave. The number of weeks of leave exceeds the employment insurance benefit length by 1 week, just in recognition for the waiting period. Employees should be aware of this before taking their leave. Leave can start at any time within 13 weeks leading up to the estimated due date and no later than the date of birth. If pregnancy interferes with an employee's job or role performance during the 12 weeks before their due date, employers may require that the employee start maternity leave by notifying the employee in writing. Birth mothers must take at least 6 weeks after birth for health reasons, unless the employer agrees to an early return to duty and the employee provides a medical certificate stating that the return will not endanger her health. In the unfortunate situation of pregnancy loss, a pregnancy loss is determined as any situation where a pregnancy ends other than a live birth. If pregnancy loss occurs within 16 weeks of the estimated due date, the employee is still entitled to maternity leave, but is not entitled to parental leave. The leave will end 16 weeks after it begins. Bereaved employees impacted by pregnancy loss may also be required or entitled to bereavement leave dependent on your corporate and company policies. Parental leave for birth and adoptive parents can take up to 62 weeks of unpaid parental leave. The number of weeks of leave exceeds the employment insurance benefit, here again, length by 1 week in recognition of the waiting period. Employees should be aware of this before taking their leave. Parental leave can be taken by the birth mother immediately following the maternity leave, the other parent, adoptive parents, or both parents shared between them. Leave can start anytime after a birth or adoption of a child, but must be completed within 78 weeks of the date the baby is born or placed with the parents. Benefit plans do differ from one employer to another, and some employers administer their own sick leave policies, such as salary continuance plans, short-term disability plans, and others have other long-term disability insurance plans as well, administered by external insurance companies. As an employer, you must know what your benefit plans are available to your employees and how they are applied in these situations. Whatever your employee benefit plan is, it should not discriminate against a pregnant employee because they are taking leave due to pregnancy or childbirth or due to parental leave. As an employer, if you do pay all or part of your employee benefit premiums, you are responsible for continuing to pay that portion of these premiums for the time that your employee is on leave due to pregnancy or childbirth. If the employee is pregnant, your employer cannot make you prepay these premiums in advance. You're also not required to pay the employer portion during the valid health-related part of the leave due to pregnancy or childbirth as an employer. Normally, the employee and the employer continue to pay the same portions that each of them would have paid during the regular work process, following the same schedule of payment as well. Benefit plans do differ between employers. It's important as an employee to check with the employer for information about the benefit plan. And as an employer, it would be really important to detail this into your guidelines and policy manuals. If you are covered by a collective agreement, you may also need to check with your union. So returning to work. When ending maternity or parental leave, employees must give their employers written notice of at least 4 weeks before they return to work, or if they choose not to return to work before their leave ends. Employers aren't required to reinstate employees who fail to give notice or report to work the day after their leave is supposed to end, unless the failure is due to unforeseen or unpreventable circumstances. If an unexpected circumstance does occur, as an employer, you can approve an extension for the leave, but you're not obligated to do so. Annual vacation earned prior to leave must be taken within 12 months after it was earned. If this time falls while the employee is on leave, then the employee must either take the remaining vacation time at the end of their leave or get approval from you as the employer to take vacation time at a later date. These also will be necessary to be outlined in your policy manuals. For breastfeeding, chest feeding accommodations, employers do have a responsibility to accommodate an employee's needs to breastfeeding and chest feeding up to the point of undue hardship. Employers and pregnant employees should discuss these options respectfully and be open to working together to explore and agree upon the best solution at the earliest opportunity. And this involves open communication, creativity, some flexibility, and often some compromise as well by both parties. It's a sensitive topic for some employees, so having the opportunity to have these discussions prior to maternity leave may be beneficial to you as well as an employer to show the understanding and the compassion and the support towards the new parent. The parties should also remain open to discussing and adjusting any previously agreed upon solution if circumstances during the pregnancy leave do change. So if the workplace is unionized, union representatives should be welcome participants to these discussions, and they should facilitate options and ensure flexible solutions from their sides as well. As an employee, before your child is born, it's important to talk to your employer about your breastfeeding plans. Work out those details of where you can breastfeed or pump. Decide how you will store your breast milk. Also plan for how often you will need to breastfeed or pump and how long that will take. The number of breaks you will need to take at work is important to discuss with your employer, and breastfeeding before or after work is also an option if you are trying to limit the number of breaks during your workday. These are really important conversations to have, and even more so, equally important to have these written in your policy guidelines as an HR leader and any leader in an organization. Employees who do breastfeed, chest feed, or express and pump breast milk should be provided with this accommodation, which can include a suitable, clean place to breastfeed or express milk and store milk, providing longer or extra breaks for the purposes of breastfeeding, chest feeding, and expressing milk, allowing for any extension of maternity leave if necessary, and also having the flexibility to allow for alternative work arrangements as well. And of course, when returning to work, it is up to the employee to ensure that prior to returning to work, early or otherwise, they do inform Service Canada as soon as possible. At that time, Service Canada will stop paying out the employment insurance benefits. I hope this information has helped. Again, the guidebook for employment standards codes is going to be very important to integrate and work alongside your in-house legal counsel or your external legal support for your organization. But definitely take a look at the updates today during this webinar that Catherine has provided as well, and integrate that information into your existing policy manuals as well. I'll turn it back now to Evan and Catherine for our next steps.
Awesome. Thank you so much, Rena. So just jumping over before the question period, we do have lots of resources available. We have a fancy new website that has a lot of really helpful information. We have materials that can be downloaded, such as our information sheets, as well as human rights guides, including the one today that discusses parental leave, pregnancy, chest feeding, and how to accommodate those in the workplace. And they're a bit more in depth than this webinar. And we also have an e-learning section, which contains webinars and videos on a variety of issues and topics. And you can also subscribe to our quarterly human rights newsletter, which is called AHRIS, AHRIS. And there will be a link to the website posted in the chat box. Additionally, although we are going to have some questions funneled out for our awesome presenters to answer, some of them may be a bit too general for folks. So if folks have particular questions that are unique to their workplace or just want to talk it out with a human rights officer, this is our confidential inquiry line. So you can give this a call and an officer will get back to you to discuss through any human rights related concern that you have. Additionally, there is a toll-free option as well as a video relay service for folks who are deaf or hard of hearing or speech impaired, or we have access to interpretation and translator services for our folks who may not find just phoning in as accessible as they need. So this, in addition, is our survey link. So we ask that if you could please take the time to fill out the survey today. We really enjoy the feedback. It's super helpful for doing webinars in the future. So you can scan this or go through the link that will be posted in the chat box, and we really appreciate your time and your feedback. For those of you who have the time and capacity to stick around, we have been monitoring the questions, and we're going to funnel out some questions to our presenters. So I'm going to start doing that. But if you do have to leave us at this point, thank you so much for coming. We really appreciate your time and have a good day. So jumping over to the questions, our first question. So for Rena and Catherine, if the employer can prove or show it was performance related despite the person being pregnant, the employer should be in the clear, correct? So I'm assuming this applies to the termination of an employee. So if it's performance concerns that they were having.
Short answer, yes. The act only prohibits discrimination if the reason for the termination was related to the pregnancy. So if it was unrelated to pregnancy, that's fine. Now, the trick for employers, of course, is being able to have the evidence that documents that that was the case. And some of the cases speak to timing. So for example, employees not disciplined, not disciplined, not disciplined, tells them they're pregnant, now they're disciplined the next day. That's a problem for the employer. So the employer is going to have to be able to show that there was a legitimate reason for the adverse impact and not the pregnancy.
Awesome. Rena, did you have anything you wanted to add on this one?
Nothing on that one. Thank you, Catherine.
Perfect. So our next question is, after an employee returns from maternity leave and finds out that they are not getting a raise for the next year, like everyone else is, because they didn't work the last year because they were on maternity leave, would it be considered discrimination and or negative treatment?
I don't know if Rena has a good answer for this one. I will say this is actually a complex area that might need a legal advice or maybe one where you speak through a human rights officer. For me, just thinking about the legal framework, the question for me is, was the lack of the raise but for her pregnancy? It kind of seems like yes. But then the next part of it is, but is that reasonable and justifiable based on experience, right? And the increment was given based on service. Now there is an important Supreme Court of Canada case from 2020 called Fraser versus Canada involving RCMP officers who got a lesser entitlement to pensions based on the fact that they had job shared. And the Supreme Court of Canada found that was discrimination. So I think there's a little bit of flux in the area, and it's really going to depend on a lot of the facts and what the evidence is behind it. It looks like it's prima facie discrimination, but the question is it reasonable and justifiable based on the employer's terms and all the things, and how does that impact female workers more so than other workers? So unfortunately, I can't give you a black and white yes or no on that question. But Rena might have some other thoughts based on her experience. But I would say that that's a really important one to get good legal advice on.
Absolutely. To supplement what Catherine has shared with us, is it's even more important if you're in a human resources role or if you're a leader in an organization to have touch points in performance management reviews and processes in place that will actually help in determining those measures and measures of outcomes, measures of performance through the year. It's again, to Catherine's point, it's very, very dependent on the organization and the organization structure. If there's a union in place and if there's increases based just on service and time alone. But equally important would be for HR leaders in an organization to ensure that they have a performance management system in place that actually has measurable and tangible outcomes to offer support in meeting the criteria for increases for each employee. So I don't know if that helps answer the question, but I do think that it could benefit every organization to be able to take a look at their performance management processes quarterly and ensure that leaders are meeting with their employees to discuss performance, any issues or accolades throughout the year, and have those documented and measured periodically.
Awesome. Thank you. So we do have another one. We have a few more coming in. So what if an employer decides during a parental leave that they prefer the temporary replacement because they are more efficient and decide to keep them and terminate the employee that was or is currently on parental leave? So I think the question is like, would this be discriminatory? Like, what's kind of your thoughts surrounding this?
So this is another one where I would say I think you need a more detailed legal advice than I can give in a public forum. I mean, the basic law is you cannot be terminated because of your pregnancy. That is the law, right? And the law is also that an employer has to hold a pregnant employee's job for them. After that, what an employer chooses to do because of fit, preference, if it has nothing to do with pregnancy, it's fine. From a legal standpoint, not from a moral standpoint, I want to be clear about that, but from a legal standpoint. But this particular question, I think should be discussed with legal counsel, because it's not, again, a black and white thing, and it depends on a lot of the factors surrounding it.
Awesome. Thank you. So our next one, so this one's kind of a bit more of a scenario question. So you have an employee who's demanding that they be allowed to work from home, but they're ready to come back to work, but they insist on remaining remote as it works better for them. But the employer hired this employee as well as all other employees to be on site. And so they tell the employee that they do not allow remote work and wants them back in the office. While a lot of the job could be done remotely, not everything could be. Does the employer have a duty to accommodate in this scenario?
Rena, I feel like I'm taking them all from you. Do you want to take this, or do you want to let me dive in?
Please go in with the legal, and I've got some great HR leadership to add to that.
So again, it's all about reasonable accommodation, right? And so, yes, there's a duty to accommodate legitimate restrictions. So, for example, if the employee is needing to work from home because of their family status and childcare obligations, we need to find out what those childcare obligations are. If they need to work from home because it's a medical issue, for example, a pregnant employee is put on bed rest, something like that, or light duties, then we want the medical that says it. The employee doesn't get to say, I would prefer to work from home from here on in, and I therefore have to. And sometimes employees will truly, honestly believe that they need that, but we need to look at what supporting documents are showing that. And I think employers should be flexible. So if an employee comes forward and they have a legitimate need that they need to work from home, the employer has to consider it and they have to look at it. But if there are things that need to be done in the office, they need to be done in the office. So the trick, in my opinion, is figuring out what really needs to be done and what the employee really needs, and then marrying those two together.
And also from, I think the emotional side, if we can talk about some of that emotional agility that does occur, both from the leader side and from the employee side, employees will value their role in the organization and feel valued as well if their request is being considered and respected. And I think that there's an opportunity for collaboration and meeting the employer in the middle and being accommodating and having those compromises mutually if the employee does show the compassion and the understanding, again, from the emotional perspective. So balancing, I think the beauty here of some of these requests coming in from employees is that as an HR leader and as a legal counsel, balancing both the logic and the emotions and understanding the flexibility of a work from home or a hybrid remote situation could beautifully work in an organization, and the retention strategies and succession planning strategies and all the things that we want to make sure that our employees remain engaged in their work and working and performing optimal, an optimal level in their roles as well.
Our next question, is there a limit on how long an employee is allowed to chest feed for? Like, for instance, if the baby is over a year old and they're still chest feeding, and I'm assuming this is applicable to human resources policies as well as the duty to accommodate.
I'm not aware of any limits. So I guess I would defer to Rena if she knows something more than I do, but yeah, I'm not aware of a time limit in law.
I support Catherine. There is no time limit that has been even created for policy standards, even in the employment standards code, for any limits.
Perfect. And this kind of leads into the next one, and kind of touches back on the remote work. If an employer doesn't want to provide a hybrid work arrangement for a chest feeding parent, citing the HR manual, are there any steps that the employee can take?
Yeah, Rena will might have some more practical perspective than I do, because I do come down quite on the adjudicative side on the legal, but the first thing is the employee needs to establish that they legitimately need this, right? And so how are they going to do that? Are they going to bring a letter from the pediatrician? Are they going to have a psychologist letter? Something to show that this is needed. It's not a preference. It's not a preferred. And it's not perfect accommodation. This is what we need. And then they need to present it to the employer as, I am requesting accommodation. At that point, the employer then needs to engage a process to look at options. But the employee needs to remember that they do need to show that they legitimately need it. And then the employer has to look at all options, and the employee has to be prepared to accept options that are not perfect and that are not preferred, as long as they meet the base requirements, so that they can meet their legal obligations, for example, to their child. And perhaps, for something like breastfeeding or chest feeding, it might be space to pump. Not necessarily I have to be at home with my child at all times. So, again, you've got to take into consideration the context of the workplace and also what the legitimate needs are.
And often what we see happening is the role that was filled by the incumbent during the leave, where the employee was on pregnancy, paternal and maternity leave. Often we do find organizations keep those individuals on board after the year or after the 18 months. And we're becoming a bit more, I guess, creative in allowing employees that do require chest feeding and accommodations for children by keeping those roles and those individuals in roles in the organizations in a hybrid format on the same team, where they can actually work the same role but in different ways during different times and still work together to fulfill the obligations for the organization and still meet the needs corporately. It doesn't always work. It depends on, of course, headcount and the number of individuals in an organization, organizational design, but in roles that can be contracted out or supplemented when employees are transitioning back to work from parental leave, it is working beautifully by just becoming a little bit more creative in meeting the guides and responsibilities of the organization, but also accommodating the needs of different employees and retaining the individual that fulfilled that role as well during that absence.
And Rena, if you don't want to shut off your mute, we do have a specific question for you in regards to what you mentioned about health benefits. So if health benefits are employer paid, that are unpaid, that those have to remain as such during the maternity and parental leave. So somebody is asking, so if they're employer paid, they remain.
That's correct. That's right. If they're employer paid, they remain consistent, no different than if the employee were still working. What the employer can't do is stop paying those premiums during the maternity leave. They must continue for the duration of the maternity leave.
Awesome. And then a general one in regards to bonuses. So if all bonuses are paid for the previous year in this year, so I'm assuming if a person is on leave during the year it's paid out, are they entitled to it as the rest of the employees are, or do they have to wait until they return to work?
So this is really similar to the raise question, which I'm going to defer to. I think you need to get legal advice about that because I think there's some complications and some nuance in that. So yeah, I think that from my end, it looks like, but for the pregnancy, they would have gotten the bonus. So that looks like prima facie discrimination. But the question is it reasonable and justifiable? And there's a lot of factors that are going to go into whether it's reasonable and justifiable. And so that's why I say I think it's actually not an answer that I can give in a black and white sort of answer.
Yeah. So and again, I'll refer folks back to that inquiry line. We do have that available as well. But jumping over to an additional question about Rena, you had mentioned that there was a waiting period for EI. So somebody's just wondering, they have read online that it's only a week total if you were applying for both maternity and parental leave. But is that incorrect? And it is 1 week per leave period total.
It's 1 week if applying for maternity leave, and not all parents take maternity leave, and some just take the parental leave. So it's 1 week. It gives that 7-day window for both maternity and parental leave. If the employee has decided to take the entire maternity and parental leave, then it is indeed just the 1 week through Service Canada. If they choose just to take the parental week, or aren't sure if they're going to continue, then it would be a week between both.
Awesome. I'm glad you understood that because I felt like that was weirdly worded, so I apologize. Additionally, is every mother eligible for EI, irrespective of their household income? I suppose that might be another nuanced one.
It's dependent on the number of months that they're employed with the employer. There does need to be that 90-day employment service with an employer to be eligible for maternity leave. However, Service Canada, there are different stipulations that can occur through EI, and as we've seen through COVID, there's different flexibilities that do come into place that could potentially support leave benefits in a different way. But again, it's just like Catherine said, it's very nuanced and it's very, very specific to each person's individual circumstances.
Now, I'll just chime in and say the Alberta Human Rights Commission doesn't have anything to do with employment insurance, including maternity leave benefits. Those are done through the federal government. So that's actually not something that the commission can directly help with.
So this is an accommodation question. How long after the return from leave does an employer have to accommodate? And is this indefinite if it is related to family status?
Interesting question. Again, it's always about the facts, but it could potentially be indefinite. Of course, the longer it goes on, the longer we potentially get into an undue hardship circumstance, right? And so I think again, there's a fair amount of nuance in here, but it also depends on how long it's legitimately needed. And again, employees are not allowed to dictate accommodation in terms of what's perfect or preferred. It's only what are my needs, and then the employer can meet those needs in a variety of ways. So the law doesn't impose time limits, but the facts might. Right. And so it's always going to be something that you're revisiting and relooking at and being mindful of.
Yeah, Rena, did you have anything for this one? I just want to make sure I'm not missing anything.
Sure, no, nothing at all to add. Thank you.
Okay, perfect. And oh, okay, interesting one. How long is a breastfeeding mother safe from termination after returning from maternity leave if she's doing her job well, so there's no other reason but family status that causes an employee to terminate her? So I'm assuming in this scenario it's a mom who's returned to work, had to make some family status accommodation requests, and is potentially terminated because of those requests themselves. And please, if this is incorrect, just put it in the question box and I'll rephrase.
Yeah, so I mean, what the act says is no employer shall discriminate in employment based on family status. The act does not put a time limit. So it's always a question of whether the family status piece is a legitimate obligation that the parent needs to meet, and what options the employer has to accommodate it. But there isn't a time limit in the legislation.
Perfect. Ooh, okay, we got a interesting one. Not like they weren't all interesting, but this is one that I think we've seen before. Are soon-to-be fathers able to request accommodations, i.e. paternity leave, even if the employer only has a maternity leave policy?
I don't know offhand, but I would say yes. My gut reaction is, if a father has family status, parenting obligations, those would be treated similarly to a mother. Parents are parents, and you have a legal obligation to your child.
Yeah, and in regards to the policy, do you have anything helpful in there? Rena, I don't know, the HR policies can get a little confusing.
Right. Parental leave is it blankets any parent. And so I think that father, mother, anyone, adoptive parents have the right to apply for parental leave.
I'll just add for clarification too, an employer cannot impose a discriminatory policy and then rely on that as a defense discrimination, right? So I think a lot of what Rena was talking about, which I agree with wholeheartedly, is being proactive in developing good processes before the questions come to you. And so I think employers should do that as a good business practice. But if there's an antiquated policy on deck that hasn't been revisited for whatever reason, the employer can't rely on that if it's discriminatory.
Awesome. So we have one here that kind of touches on all the protected grounds we've talked about, and as well as medical restrictions. So a pregnant employee has medical restrictions in place that require movement away from their normal position. So I'm assuming they're just not able to function in their current position. And the only other one that's available that meets all their restrictions is one that is paid lower. So this person's asking, are we allowed to reduce their pay if we move them to this position to accommodate their medical restrictions?
This is a tricky one. And so again, this is one, I guess, that I would say legal advice. And so you're going to have to look at all the circumstances. Now, the law does not require an employer to create a new position. And the law does not require an employer to pay for work that's not being performed. So I'll just say those as basic principles. But a lot of it is going to depend on, how long, is this a temporary patch, then maybe you just do it. If this is a permanent placement, do you have to pay them their full salary the whole time? Probably not, but again, you're gonna have to go and talk to a lawyer and look at all the options and look at the facts in real detail.
And I was going to just add is, I think just as an employer and from a human resources perspective, it's so important to have the flexibility, if the company can offer it, to each employee during this time as they prepare for leave. With the goal being retention, the goal being future succession planning. I think that even from an employer's perspective on how they engage with their employees, from a human resources attraction perspective and recruitment, you'd want to, inclusive of your policies, also have that human side, that emotional side, that the side that ties employees through relationships in the workplace and future, opportunities as well for the employee, should the employee choose not to stay, or, if there's a parting of ways. So I think just from the perspective, from an HR lens, is that if it's possible to be able to accommodate requests for employees, it would be so important at this stage specifically to do so, to make it work and work with legal counsel directly, but to do so.
Mhm. Perfect. So we have, what am I allowed to ask an employee who is requesting accommodations based on family status? So yeah, that kind of delving into like, what can you ask? What can you not ask? I think that's kind of the general vibe here.
Yeah, so I think this is one that I would say I think you need to get legal advice about. These things are quite delicate, and it is really important that the employer get the information that they need to make sure that it is a legitimate request. And it's also really important that they don't ask for too invasive of information. And with the recent Alberta Court of Appeal decision in UNA and AHS, they did distinguish that family status is not different than any other protected ground. But I think there is still going to be some evidence needed about the legitimacy of the ask. Because employees are not allowed to dictate and just say, this is what I want, so therefore you have to do it. It is a conversation and it does have to be bona fide. So it's clear you can ask for information, but I think you do need to get some advice to know specifically what in the circumstances.
Awesome. So we are coming up, we do have a hard end of 1:15, so we may not be able to get to all folks' questions. So I'll quickly refer you back. We do have our inquiry line on our website. Please go there if your question isn't asked. So we have a few more questions in a few more minutes. So I have an employee who is pregnant and has not requested accommodations. However, I am worried that their work, for example, operating heavy machinery, labor, etc., may be putting their pregnancy at risk. What can I do as an employer in this situation?
I think the first thing would be to have a conversation with the employee. It is up to the employee to raise questions, but there can be a duty to inquire. And I think Rena might have some better ideas on how to approach that conversation, but just from a legal standpoint, I would say in the first instance, it is up to the employee to raise it, but there can be a duty to inquire. And maybe not posing it in terms of, I think your pregnancy might be at risk, but to just say, these physical job tasks, are they within your physical limits during your pregnancy? And then if the employee says yes, that's the end of it. Now, if there's something you see at the workplace that is unsafe because, they're not able to physically move in a safe manner, then I would identify that and you could potentially ask for medical confirmation. But again, that's probably one that you want to get legal advice on and to be really careful. But as with most things, if we approach this warmly, candidly, and carefully to have healthy conversations, you can probably deal with it informally, and it may be that your concern is overstated. I'll tell you, when I was pregnant, I had lots of opinions about whether I ought to be doing various activities, and neither me nor my doctor agreed with those opinions. So, have the conversation, be respectful, and then move on if you get in the negative.
I would 100% agree with everything Catherine has said. There's nothing more to add other than the relationship is so important. And if you are a leader in your organization in the HR capacity role, coaching other leaders in the organization to have that relationship where you're allowed to afford employees the open communication and the ability to have those conversations versus going through documented processes. Again, it comes down to relationship building. So
Awesome. So I think we have reached the end. It is 1:15. So just to be respectful of folks' time, especially if you're working today, please look at our chat. You'll also have received information on our website, the referral line. Um, Please feel free to look through whatever resources we have available. And thank you so much to Catherine and Rena for presenting and talking and answering questions today. And thank you to everybody who participated. We really hope you gathered as much as you can and what you need from this webinar. So thanks, folks, and have a good day.